Imagine you have been living in the United States for many years. You built your life here, you worked long hours, paid your taxes, and raised your children on American soil. Then one morning you wake up and the rules you believed protected your family, rules that have existed for more than 150 years, suddenly disappear. Just like that, no warning, no transition period. Only a new reality that millions of families were never prepared for. That moment is no longer theoretical. It is unfolding right now. And if you are watching this without clearly knowing what steps to take next, you are already falling behind. Stay with me through this entire video, because in the next few minutes, I will walk you through exactly what has changed, why it changed, who it impacts, and most importantly, the exact steps every immigrant family in America should take right now before the opportunity window closes. This is not speculation. This is not political opinion. This is verified and confirmed information that could shape the future of your family's legal status in the United States. You do not want to miss a single word of what is coming next. Welcome back to Immigration Desk, the channel trusted by hundreds of thousands of immigrant families across America for clear, reliable, and timely immigration news. If this is your first time watching, press that subscribe button right now because the information shared on this channel cannot be found with a simple Google search. We go deeper, we explain more, and today we are covering one of the most significant immigration developments in modern American history. Let's begin with the foundation of what has just changed. Because to understand where things are going, you first need to understand where things have been. For 157 years, the 14th Amendment to the United States Constitution guaranteed one of the strongest legal protections in the world. It declared that any person born on American soil automatically becomes a citizen of the United States. No questions asked, no forms required. This principle, known as birthright citizenship, or by its legal term, jus soli, meaning right of the soil, has been a central part of American identity since 1868. It did not matter if your parents were citizens, visa holders, green card holders, or undocumented. If you were born in America, you were American. Full stop. That era is now changing. Through a combination of executive actions and accelerated legal proceedings, the policy structure surrounding birthright citizenship has begun undergoing a major transformation heading into 2026. The executive order aimed at birthright citizenship, which was first challenged in federal courts, has now passed several significant legal hurdles. While the complete constitutional battle is still developing, the practical enforcement systems are already being introduced. Federal agencies have started implementing new documentation rules. Hospital birth registration procedures are being updated. And most importantly, the State Department has released revised guidance for determining citizenship at birth for children of non-citizen parents. This is not some distant possibility. The system is already moving, and the families most at risk are the ones assuming they still have time to figure everything out later. Now here is where things become critically important, and this is the part that most news outlets are barely explaining. The change does not affect everyone in the same way. There are different layers, different categories, and depending on your specific immigration status, the impact on your family could be completely different from your neighbor's situation. Let me explain this in a way that is clear and practical. The first category involves children born to parents where at least one parent is a U.S. citizen or a lawful permanent resident, meaning a green card holder. For these families, the situation is less alarming. Under the new framework currently being enforced, citizenship at birth is still recognized for children in this category. If you or your spouse is a green card holder or a U.S. citizen, your child born in the United States after 2026 is still expected to receive citizenship. The key word there is expected. Because even within this category, documentation requirements have become significantly stricter. Parents will need to prove their legal status at the time of the child's birth with more documentation than before. Hospitals are now being instructed to collect and report the immigration status of parents during birth registration. This is new, this is real, and if you are not prepared with the proper documents at the time of delivery, it can create complications that might take months or even years to resolve legally. The second category, and a far more vulnerable one, includes children born to parents who are in the United States on temporary visas such as F1 student visas, H-1B work visas, B-1 and B-2 tourist visas, and other non-immigrant classifications. Here, the change is dramatic. Under the new policy being introduced, a child born in the United States to two parents who hold only temporary visa status may no longer automatically receive U.S. citizenship at birth. This represents a major reversal of decades of established practice. Families who previously planned around this possibility, parents who intentionally arranged to give birth in the United States while on valid visas, are now facing a situation where that strategy may no longer produce the outcome they expected. Then there is the third category, the one that carries the greatest urgency and concern. Children born to undocumented parents or families where one parent is undocumented. The new enforcement framework in this area is the strictest. Citizenship is no longer automatically granted, and the legal pathways for establishing citizenship for these children are currently being contested in multiple federal circuits. This uncertainty creates serious risk. Children born during this period of legal ambiguity may later face documentation challenges as they grow older. That could affect their ability to attend certain schools, access federal programs, apply for jobs, or travel internationally. Now, here's a question that many people are asking and that mainstream media is not fully answering yet. And this is where Immigration Desk goes further than most outlets. What about children who were already born in the United States before these changes took effect? What happens to their citizenship status? The answer at this time is that retroactive application of the policy has been legally blocked. Children who were born as U.S. citizens before the enforcement date continue to retain their citizenship. The changes apply prospectively, meaning going forward, not backward. However, there is still an important risk here. The documentation that proves your child's citizenship, especially if they were born close to the transition period, becomes extremely important. Passports, birth certificates, social security records, and the full documentation chain for your child should be secured, organized, and protected immediately. Not next month, not later this year, right now. This brings us to the most important part of this video, the action steps. These are concrete, practical, time-sensitive steps that every immigrant family in America should consider based on their category. If you currently hold a green card or you are a U.S. citizen with a non-citizen spouse, your first priority should be applying for naturalization if you are already eligible and have been delaying the process. The importance of that decision has just increased significantly. Having a naturalized citizen in the household changes the entire calculation for future children under the new framework. If you have been waiting to file your N-400 application, the time to act is not 6 months from now. The time is now. If you are in the United States on an H-1B, L-1, or O-1 visa and you are expecting a child or planning to have children soon, you should consult an immigration attorney immediately about your individual pathway, your visa category, your country of origin, your employer's role in your immigration case, and your timeline toward permanent residency all influence what could happen with your child's citizenship status. There is no universal answer here. Your situation is unique, and generic advice from social media or friends is not enough for a decision of this magnitude. If you are on an F1 student visa and you have given birth in the United States or are currently expecting a child, the urgency becomes even greater. F1 visa holders represent one of the largest groups affected by the new temporary visa provisions. If your child was born before the enforcement date, immediately secure their birth certificate and social security card and apply for a U.S. passport as proof of their citizenship. Do this even if you do not plan to travel internationally. A U.S. passport is considered the strongest document for proving citizenship, and having it issued before any further policy changes occur creates a powerful legal protection that is extremely difficult to challenge. For families who are undocumented or who have mixed immigration status within the household, the situation becomes more complex and more urgent at the same time. There are legal organizations operating across the United States that specialize in helping families in exactly these situations. Groups such as the National Immigration Law Center and the Immigration Advocates Network provide low-cost and sometimes free consultations for families facing immigration vulnerability. Reaching out to them before a crisis occurs is far more effective than seeking help after problems have already developed. And if you have children who were born in the United States under the previous framework, obtaining a passport for them now is one of the most important steps you can take to protect their citizenship from future administrative challenges. Now let me address something that a large portion of the Immigration Desk audience has been asking about: the legal challenge landscape. Because this story is far from over. The Birthright Citizenship Executive Order and the policies implementing it have triggered a massive wave of federal litigation. Several circuit courts have issued conflicting rulings. The Supreme Court has been signaled that this issue may eventually come before it. And that legal uncertainty cuts both ways. On one hand, it means there is a possibility that some parts of this policy could eventually be overturned or modified. But it also means that families who are waiting for the courts to resolve everything before taking action are taking a significant risk. Court processes move slowly, while policy implementation can move quickly. Families who prepare regardless of the legal outcome will always be in a stronger position than those who simply wait and hope the courts solve the problem. There is also an international dimension to this issue that very few people are discussing, yet it matters enormously for families with ties to other countries. If your child is born in the United States after the new policy takes full effect and does not receive automatic U.S. citizenship, their citizenship status may depend entirely on the laws of their parents' home country. Some countries grant citizenship based on parentage, a system called jus sanguinis, meaning right of blood. If your home country follows this system, your child may automatically become a citizen of that country through you. However, there are complications. Not all countries treat dual citizenship the same way. Some countries have gender-based restrictions on passing citizenship to children. Others require registration at a consulate within a certain period after birth, or the child may lose eligibility for citizenship by descent. If you are a non-citizen living in the United States and expecting a child, contacting your home country's consulate now to understand their requirements and deadlines is extremely important. This is not a minor administrative detail. It is about making sure your child legally belongs to a country from the moment they are born. Let me share a realistic example to explain why all of this matters. Imagine a family from India living in Texas on H-1B visas and expecting their first child in late 2026. Under the previous rules, their child would automatically be born a U.S. citizen. Under the new framework, that automatic citizenship may not apply. The parents are temporary visa holders. Under the new guidance, their child may not receive U.S. citizenship automatically. Meanwhile, the parents are already waiting in a long green card backlog, which is common for Indian nationals due to country limits, and their priority date could still be years away. India does allow citizenship by descent, but it requires consular registration within a specific time frame. If the parents are unaware of this requirement and miss that registration window with the Indian consulate, their child could end up in a difficult situation, not automatically American under the new rules, and not properly registered as Indian either. This type of scenario is already happening to real families. And the difference between the families who navigate it safely and the ones who face serious complications almost always comes down to one thing: information and preparation. Before we close, there is one more important issue to address. Right now, there is a significant wave of misinformation spreading through immigrant communities about this topic. Many people are sharing outdated details, incorrect interpretations of the law, and sometimes completely false claims about what the new policies actually mean. Some of this misinformation is unintentional, people simply sharing what they think they understood. But some of it is more concerning, coming from individuals trying to profit from fear by offering legal services that are unnecessary or even fraudulent. If someone tells you that you must urgently pay them to protect your child's citizenship through some special filing process you have never heard about before, that should immediately raise a red flag. Legitimate immigration attorneys do not operate through panic tactics. They operate through proper consultation, documentation, and legal procedure. The Immigration Desk channel exists specifically to cut through that confusion and provide verified and trustworthy information so families can make informed decisions rather than fear-based ones. Here is the situation as it stands today. Birthright citizenship, as it has existed since 1868, is going through one of the most significant transformations in American history. The policy changes are real, they are already moving forward, and they affect different families in different ways. Children of U.S. citizens and green card holders remain largely protected, although documentation requirements are becoming stricter. Children of temporary visa holders face new uncertainty. Children of undocumented parents face the highest level of vulnerability, and all families, regardless of immigration status, should act proactively right now by organizing documentation, seeking legal guidance, and understanding their specific circumstances instead of relying on general assumptions. The families who successfully navigate this transition with their status protected and their future secure will not necessarily be the ones with the most money or the most powerful lawyers. They will be the families who became informed early, took the right steps in the correct order, and did not wait for someone else to fix the problem for them. That is exactly why this channel exists and why you are watching right now. If this video helped you understand something you did not fully know before, take 2 seconds and press the like button. It costs nothing, but it helps this information reach the families who need it most. Share this video with anyone in your family, community, or social circle who has children or is expecting children and is living in the United States on any immigration status. This is the kind of information that can truly change outcomes. And subscribe to Immigration Desk if you have not already, because we will continue covering every new development in this story as it unfolds. The court decisions, agency updates, consular guidance, and the practical steps you need to stay ahead of each change. The rules surrounding American citizenship are shifting, and the families who understand that and act accordingly will be the ones who stay protected.